Good morning to everyone and good day. And I hope you and your families are safe. I'm Seshadri and will be your moderator for this session. A quick introduction about myself. I'm currently a senior director leading the security audits, risk and compliance in the office of the CISO at Unisys Corporation. In my current role, I lead a very talented bunch of cybersecurity professionals to help protect, enable, and grow the firm and working with various business stakeholders. I have, prior to my role at Unisys, I've also worked in diverse industries like automotive, engineering services with over around 3 decades of experience. Outside of my work as a part of volunteering, I'm currently the co-chair of the Bangalore chapter of IAPP, which is the International Association of Privacy Professionals. With that, the topic of today's panel discussion is balancing privacy and public good. So never has this topic evinced more interest than the world we are living in today, especially with the pandemic. There are a number of questions that are in people's mind. For example, how much access should governments have to people's data? How will it be used? Where are we on the technology advancements in having a truly privacy preserving platform that can be implemented at scale? What are the legal regulatory frameworks that are needed to support all of this? And finally, where should the balance between the public interest and privacy reside? So, to discuss all of this and more, we have a very interesting and diverse panel today. Each one of the panelists are experts in their field, and I would take the opportunity to introduce our panelists. I will start with Rahul. Mr. Rahul Matan is a partner at Trilegal, which is a law firm based in India. He is part of the TMT practice group of the firm. Rahul has advised on some of the largest TMT transactions in the country. He has worked with companies across all sectors of the industry, from big telecom operators to ISPs, OSPs, and managed data service providers, advised on matters ranging from regulatory matters to ongoing business issues relating to rollout of operations. Rahul has also advised on a range of sectors in the technology space. He's also been very actively involved in a number of policy initiatives in the TMT space, including assisting the government in preparing the country's privacy law. He is a published author and a regular speaker across the world in matters relating to emerging technologies and law, and writes a weekly column on the interface in law and technology. Rahul now serves on the board of Trilegal after having served for many years in the firm's management committee. Welcome, Rahul. Our next panelist is Mr. Munish Mudgil. Mr. Munish is an electrical engineer from IIT Bombay and an IS officer from the 1998 batch Karnataka cadre. He is currently the secretary of the Department of Administrative Reforms and posted as head Karnataka State COVID War Room. In his distinguished career, he has worked in various capacities. In fact, he was handpicked by the state government to head the state COVID War Room to coordinate all parts of COVID management. In his prior roles as Commissioner Survey, he headed the state land records and survey and brought land records and maps on mobile through Dishank with more than 1 million downloads. Previously, he headed the citizen service delivery that created the online and ready-made repository of caste, income, and residence certificates. This effort actually won the National E-Governance Award in 1920. He has many other notable accomplishments to his credit throughout his career, which I will not touch upon today due to time constraints. Welcome, Mr. Munish, to this panel.
Thank you.
Our last panelist, but not the least, is Dr. Satya Lokam. Dr. Satya Lokam is a principal researcher at Microsoft Research Bangalore. His research interests include cryptography, complexity theory, and theoretical computer science in general. Recently, he has also been working on research related to privacy preserving data governance in blockchains. Before moving to Microsoft Research, Satya was a faculty member at the University of Michigan, Ann Arbor. He received his PhD from the University of Chicago and held postdoctoral positions at the University of Toronto and at the Institute for Advanced Studies in Princeton, New Jersey. Welcome, Satya.
Thank you.
So I'm delighted to be, the moderator of such a distinguished panel. So we will, start with a few questions to each of the panelists and then from there take it forward. So I would start with Rahul. Rahul, the COVID-19 pandemic has opened up an important conversation regarding how we balance interests of privacy with public health. Our own Arogya Setu app was launched in April and has more than 160 million downloads as of date. But there are concerns that these come at the expense of data privacy. So I wanted to get your thoughts on a couple of areas. One is, what is the importance of privacy and the key design elements that have been considered to keep the right balance between privacy and societal benefits? And the second is, as the pandemic has evolved, we have seen other global models coming out, like the Google Apple initiative. And it would be good to see or great to hear your views in terms of how do we compare that to the India model from a privacy preserving perspective. Rahul?
So thanks, Sesh, and it's a pleasure to be here on this panel. You're right. Look, at the end of the day, privacy and the regulation of privacy is a trade-off. So, on the one hand, we can have perfect privacy, but if we have perfect privacy, we lose a lot of good benefits that we can get out of the maximization of data. On the other hand, if we maximize data, we lose the essential requirements of life and liberty, which include privacy, as was laid down by the Supreme Court in its 9-judge bench decision, which said that we now have a fundamental right to privacy. So at the end of the day, this regulation of privacy and regulation of data has to find the correct spot on that spectrum, where we can maximize data but minimize privacy harm. And in what I call peacetime, there is this is a difficult balance to find in any event. But in a situation like this, when you've got a global pandemic of a disease that is very difficult to spot and that is infectious and fatal, it puts a greater stress on this sort of balance finding. So when we looked at Arogya Setu and when we looked at what are the measures to apply in Arogya Setu, I think the first thing that we've got to recognize is at this point in time we don't have a privacy law. So the privacy law is currently before the Joint Parliamentary Committee. Hopefully the Joint Parliamentary Committee will submit its report in the next session of Parliament, which means that we may have a law in sometime in the course of next year. But what we do have is the fundamental right to privacy decision, which imposes on the government a requirement to be proportionate in its actions with regard to privacy. And so when we were working on the privacy framework for Arogya Setu, the way we thought about it was, let's see how we can be proportionate in the data that we collect. And so the Arogya Setu design actually has a few elements that demonstrate this proportionality. In the first instance, data that is collected, and understand that there is fairly personal data that is being collected. Every time you come in contact with someone or come close enough to someone who also has the apps will exchange information about that person. There is location information that is being collected. And of course, all of this information when put together can provide some fairly insightful information about who is infected and who is likely to infect other people, all of which could potentially be a violation to privacy. So how do we mitigate that? So the first thing we do is we ensure that the data remains on the phone as far as possible. And it is only when you are actually declared to be infected that that data is pulled from your phone to the central server where it is analyzed for contacts. The data that is on your phone is deleted on a 30-day rolling cycle, which means that we know that the infection period is 14 days. Let's double that, 30 days. Beyond 30 days, that information is less relevant. So we actually delete the information on the phone, and if at a 60-day period after you have been declared of COVID infection. So even at the server level, there is a deletion of the data that takes place. So the principle that we are following here is that we need this data, and there is a recognition that this data is actually helpful, even to some extent, in the contact tracing element, which is important for this disease. We can do it manually, and we certainly should continue to do it manually. But this provides an additional tool that we can use to improve our detection of the disease. But just because of that, we shouldn't keep the information for longer than is necessary, and we should only use the information for the purposes that is required. both of those are elements of the proportionality requirement that the Supreme Court has imposed on the government in order to use personal data. So that, I think, is the answer to your first question, in that, how do we use the data? How do we find the balance? If there's another pandemic that comes, or if there's any other situation that comes where we need to use personal data, these are the principles that we need to apply. We need to actually look to see what the purpose is, take the data that we need for it, use it for the purpose, and don't use it beyond that. On your second question, with regard to the other models that have come up, obviously the big model that has come up is the Google Apple contact tracing model, which is an aggressively decentralized model. So under that model, it is the apps themselves which share information among each other, and they are sort of increasing your probability of infection based on some sort of an algorithm, which is completely decentralized, which means that there is no central place where this data is collected. And once again, when I started, I talked about the spectrum. This is aggressively on the spectrum of privacy preservation, where you depend on the algorithm that has been fed in to come to the correct conclusion. Now, the problem with this is that algorithm cannot detect things like, is there masking taking place? Is this a contact where people are actually coming close together, close enough for the Bluetooth proximity to happen, but they are in two cars with the glasses up, right? And so when you go to the aggressive decentralized model, you tend to lose some of the benefits of this sort of an interrogation. India has followed a quasi-decentralized model, which is that the data remains decentralized on the phone until it is required to be analyzed. Then it is actually pulled to a central location, and only that information is pulled off someone who is infected. So it's not everyone's information that is pulled. But since it is pulled to a central location, there is an additional layer of analysis that can actually take place before it is put down. So, I don't want to say something is good or bad. I think, everyone needs to figure out for themselves where on the spectrum they need to be. But it's good that you raise these two, because the India model is sort of a middle path. I think just to close the loop, UK has a completely centralized model for contact tracing, where all the information is centralized to a location and pulled off the phone. I think that is one extreme. Apple is the other extreme, and India is sort of in the middle path.
No, thanks, Rahul. I think that was very insightful. In fact, I think only with time, moving forward and seeing how these work, the effectiveness of these models, we'll really be able to say, which is the right path, right? But, thanks for the, very clear explanation of, the different models that are in play, and also the privacy principles that has gone into, the design of the Arogya Setu app. Related to COVID, I want to move to Mr. Munish. Sir, I want to talk to you about the importance of data, right? Given that your role in the managing the state COVID war room, it's a huge effort. There's so much of data. There is information portal, there's citizens reports, there's contact tracing reports, there is quarantine watch, health watch, travelers watch, things like that. And I believe there's much more initiative that is being planned to serve the public in a more effective and targeted manner. One area that I wanted to ask you, sir, is, how does usage of personal data help better delivery of public services? As you've seen, it could be in this COVID situation and beyond COVID. And obviously, technology has solutions to help us make choices to mitigate privacy risks. Where do you see that balance?
Yeah, thank you. I'd like to mention one thing from where Rahul left. The Supreme Court judgment is there to touch upon this point for maybe a minute or so. See, the proportionality cannot be, finally, it will always courts any action of the government, or for that matter, in any situation. The practical reality is that the courts cannot keep on intervening at all the points of time to tell where is that proportionality. To put it conversely, in any, the executive or the government will have to take a call to draw the contours of having a balance between the privacy and the public good. And, because we cannot keep on going back to the courts to know whether what we have done is right or wrong. We'll do something to the best of our understanding, balancing the privacy and the public good, getting that proportionality. And if somebody has an issue, he can go to the court. Why I'm saying all this is that, the public at large and the government need to understand how do we reach this proportionality. Saying there is a proportionality does not answer the core question, because my sense of proportionality will be proportionality, and every individual will have a slightly different take on where that sweet spot of balance between privacy and public good lies. So what I would say is that if we don't know where that balance lies, which is a fact, because every individual have at least can have who will decide where that balance lies. And I would say naturally that most naturally it lies with the government to take a call where that balance of proportionality between the public good and the privacy lies. Every individual in a free society has a right to have his opinion and absolutely be entitled to it. And if he thinks that any action of the government is, he is not in consonance as he believes is the law of the land, he can approach the court. What I mean to say is, even I feel that this much level of understanding that government on a day-to-day basis has the right to take this call. And if in case anybody has an issue, courts, this level of understanding itself is a hugely step forward in my view. And government is actually of the people, for the people, by the people. Just because you have a very strong view, let us say either in favor of public good, expecting that government should go and check everybody's everything, or conversely you have a very strong view that government should look into anything, you must understand that there is a spectrum of views, and as a legal entity has that right at any point of time to balance that thing, and you must respect that balance in a democratic manner, in the not take to streets, become offended as to become violent in some sense. I just want to put one point in this. People, I believe, have a misconception, in my view, that when you silently obstruct others, that is also a sort of violence. So people silently protesting, so that's democratic. And, your protest extends to the point where you don't disturb the life of another human being. The minute you are disturbing or interfering with the right of another human being, then naturally, your independence and your freedom to act gets curtailed to that extent. Until that point, you're absolutely free. So why I'm saying all this is that while the proportionality has been well laid out by Rahul, and Supreme Court has said that, and it is the arbiter of the whole thing, we must understand that government needs to act on a day-to-day basis, take decisions in public good. And okay, I'll just close this with one sentence. See, to put it in a simplistic manner, okay, I would say authority of any individual or an institution is directly proportional to the responsibility it discharges. If we as a society are calling upon government to do something, let us say about COVID, which means we hold it responsible and accountable to solve COVID, it need to have an authority to do that. If we are, for example, in a football match, going to hold the referee accountable what happens on the field, you need to give him the authority to show a red card and a yellow card. So that's how it works. So the proportionality, what I would say is that if the societal expectation is the government to control COVID, the necessity requirements which the government requires, the controls to ensure the COVID is controlled, need to be reposed in the government. If we, I feel that correlation sometimes is missing. We expect the government to control, but without having the levers of control to ensure the delivery of the control. Now I'll come back to your question. See, the data, huge data is actually available with the government. To be very frank, there is, hardly, I would take it even more fundamental now that the Supreme Court has said that the privacy is a fundamental right. The issue is no longer open to debate, but it is absolutely open to our understanding. We may not debate it, we absolutely accept it. But I want to understand when we say something is a fundamental right, what is at the core of it? You know, say that, privacy is a fundamental right. What I mean to say, please understand that the government already has virtually all of data. We have the ration cards, we have your driving license data, we have your taxation details, we have your, you name it. There's hardly any data of a, people who are actually speaking, the intellectuals, virtually their whole of data is with the government. And what I would say is that coming back now, in that sense, that government is not acquiring new data, if I would say. It's actually acquiring a lot of your data, a lot of your data. Is this government, since you asked me a specific question, how and where the government needs to use this data? Why should the government keep the data at all? What is the need for keep data? I would give an example. Like, if we are, for example, we take the example of COVID, then if we need to, I mean, so axiomatic, if I am COVID positive and I'm going to infect somebody else because I'm COVID positive, the minute I am discovered to be a COVID positive, unless I tell those people whom I was in touch with, how are we going to control the disease? I mean, I don't know how more lucidly I can put it, because in COVID, any person who is positive can infect others for a period of 14 days. If Munish has been in touch with 10 people over the 14 days period before he got discovered, he could have potentially infected these 10 people. Without telling these 10 people that you could be potentially infected, how do we control the COVID? So since the minute this data will become available to, for example, Munish, for example, to government, that Munish is positive, what we are expecting the government is to manually extract this information from Munish, whom all he was in touch with. It is firstly practically impossible for Munish to get this data. Secondly, because he could be in touch with people he wouldn't know. Secondly, many of the times we are experiencing the people are deliberately not sharing data. I can tell you, people want to be true to their individual friends than to the society. I have seen this behavior. Why, if you tell your friend's name, he will be quarantined for 14 days. This is the reason people are not telling their friends and relatives' name whom they were in touch with. So what tends to happen is, unless we know whom he was in touch with, unless we notify this person that he's in touch with, he is now COVID positive, the rate of infection of COVID will be, that will make a difference between loading COVID and controlled COVID. An absolute scientific fact. Again, I'll repeat, when we notify people that they have been in touch with a person who has been COVID positive and they could potentially be positive, that piece of information to the relevant person makes a difference between an exploding, exponentially increasing COVID or a controlled COVID in a society. Now, we, like a child, if I say that, we want to control COVID, but we don't want to give information which controls COVID. I mean, this is one example. To put the example in a positive way, this is a negative way of putting, you think somebody is snooping at you and all that. If the government wants to serve you, as one of the projects which you mentioned, which we did, I'll give an example of Estonia. Okay, I'll give the example of even America and most of the Western countries where the privacy is extremely valued. When you turn up at the government, I'll give one small example. When you are born, you're born to naturally your parents. You are registered. Your parents have a history and the data with the government. Let us say you are eligible for a scholarship from the government because you belong to an economically weaker section, etc. Today, you will end up paying large amount of bribes to get any service delivered from the government. Why? Because when you reach this office to get, let's say, this or any financial benefits from the government, the person, manual human being who is in charge of delivery of this service is extract money out of you. This is a general experience of everybody. But look at the reality. If we are able to, which the government is trying, marry the databases where the ration card data is exchanged and interlinked for Munish to the pension or the school admission data, etc., and so on and so forth. What will happen is, imagine a child takes birth. We know his father is a, belonging to a weaker section because we have got his, and because we know he belongs to this weaker section, The minute the child is born and the birth is registered, immediately the child becomes eligible for the scholarship which he is entitled to. The minute he takes admission to the school, he doesn't have to apply. Why? Because the government already has the data that his father belongs to weaker section. We already have that data. We know that child is born to this man. We also know that this child is now taking admission in X school. And after that, the minute he takes admission, I would say the money can start flowing for the scholarship of that child. Today, this is not happening. I'll put it in a single sentence. The holy grail of government service delivery, in my view, is a citizen gets the service delivered before he applies for it. That is what is possible. Because the information already exists with the government. Instead of the people applying for a service, then some clerk or some officer sitting in judgment over it, and then giving you that approval. This can go from the smallest spectrum of getting admission to Anganwadi center to opening up a big industry. So if this kind of data is enabled and in the favor of the citizen, I believe this is really like heaven, which is possible. Thank you.
Absolutely, sir. I think your points have been very valid, given that we are in the middle of a COVID, and this is really stuff done on the ground, right? So there is so much of work that there's a human of effort that's gone into making sure that the war room is running and so on. And we didn't touch, although all three of you, there's one common thing that I really see is the technology aspect. And technology is a big leveler, and we do have Satya today in the panel, and it will be a good segue to move to Satya and really get his point of view in terms of from a technology perspective, and if you put a technology lens to this, and specifically the research that he's been working on. Satya, can you share with us, some of the key elements of the work on technology platforms, not just for COVID, but that can leverage data at scale, and at the same time, preserve the privacy that Mr. Munish was talking about, right? In terms of making sure we have help better delivery of public services, so that the government, private companies, everybody can really make sure that they have the necessary data, but they do not have access beyond the intended use. So Satya, do you want to talk a little bit about the technical aspect?
Yeah, sure. Yeah. I agree with many of the points that both Rahul and Munish made, namely, a policy framework and a legal system that defines the policy in the interests of all stakeholders is really critical. And the purpose of these policies people of a country or people of the world at large. But then, as Rahul frequently pointed out right in the beginning, the challenge always is to strike a balance between the social welfare as a result of implementing these policies and individual privacy. And I will not get into the details of what the right policies are and what the legal framework that should define as well as enforce the policies should be. There are better experts to do that than I can. But my starting point is that suppose we do have such a robust policy framework that, according to some social welfare metric, achieves a good balance between privacy and social good. Then the question really is, how do we technology? After all, technology is really just a tool. It is, it does what you tell it to do. And so what you tell it to do is really important. And how you tell it to do and make that accountable. The implementation of technology based on policies is accountable in the right way is where, we come into picture. I mean, people who build technology tools to build privacy preserving platforms or COVID tracing apps or health permits and so on, they come into picture where they have to really make sure that the technology, first of all, is compliant with the policies. But now, so let's come to compliance. I mean, compliance often, and for the most part today, the way it happens is post facto. And basically, the technology builder interprets the policy, to the extent that they can, and then they build a technology tool like a contact tracing app. And then, of course, there will be pros and cons, and there will be criticisms from both sides. Is it too centralized? Is it too decentralized? And then you need to remedy these situations. And like Mr. Munish said, you probably can go. The point I want to make is this post facto approach is often not good enough. And that's not good enough because by the time you discover a policy violation, the harm has already been done. I mean, many people might have already been infected. Many people might have already lost their lives. And, less dramatically, many people might have lost valuable personal information, into unauthorized entities, right? So what we are proposing is to actually build technology that proactively enforces policies. And we argue that this is in fact possible. So like I said, our starting point is to actually have a policy layer. And we really require this policy layer to have at least 3 important criteria, right? One, it should be unambiguous. And a lot of times policies are subject to interpretation. And again, like Mr. Mudgal said, I interpret in one way, you interpret in another way. And then if there is a conflict, we go resolve in the courts. But like I said, this could actually be too late and too little too late. So to begin with, the policy should be unambiguous. Now, of course, you have to define what it means to be unambiguous, right? So the second thing is it should certainly be unambiguous from a human interpretation point of view. But more importantly, for the things that I want to advocate here, it should be codifiable. It should be codifiable into a machine interpretable language. And actually, that's kind of perhaps one of the litmus tests, whether a policy is unambiguous or not. And today it is possible. I mean, it is possible not necessarily for, for the policy framework for the entire country in all domains, but if you restrict yourself to narrow enough domains, like for example, COVID-19, or a particular healthcare scenario, or a particular exchange data flow, if you restrict yourself the interpretation of policy to narrow enough domains, it's possible to say, is the policy unambiguous? Is the policy codifiable in a machine interpretable way? And we have technological tools to do this, and to not only codify the policy, but also enforce that policy as the computation happens, as the data is acquired. I mean, when the data is acquired, you can actually again, consent would be an example, but that's not the only example. When you acquire the consent, there are certain, consent is kind of the, heart of the DEPA in India, which is now used as kind of the, the most prominent way to share data amongst entities. And so the principle, not the principles, I'm sorry, the explicit agreements that are made in the consent by the user for their PII to be exchanged, or if this consent is between organizations, what the data is. Now that can be codified into a programmable interpretation. And we have technological tools based on cryptography, based on trusted hardware, that would implement these policies from the state of data collection from end user to its consumption by the information user and everything in between. And this is kind of the bottom line I want to say, and I can go into the details if anybody is interested, is that it is possible to do so, and therefore the emphasis should be proactive enforcement of policies and not reactive enforcement. And not punitive actions. Of course, punitive actions are important. Punitive actions are needed because you can never be 100% unambiguous. You can never be 100% guaranteed. And so audits will still play a role, and legal actions will still play a role. But the more you bring to the an automated enforcement of policies into technology, the more rigid or more rigorous we can get in terms of guaranteeing privacy. Okay, I'll stop there. And if anybody has any questions, I'm happy to go into details.
Thank you, Satya. So I think this was a good overlay of how the technical or the technology components come in here, because that's an important aspect. People have to start thinking like you've started doing your research in terms of platforms. How can data come together, all the different data come together in one place, and so on and so forth. I know we do not have enough time. This was meant to be a 30-minute panel discussion, so I'll have a quick 35 to 40 seconds or maybe 50 seconds or a minute for each of you, as a closing remark. Rahul, I'll start with you. Having heard all the panelists, do you want to go for comment remarks or anything that you'd like to share?
So look, I've heard everyone, and I think points on all sides are well taken. I think it's quite clear that we have vested in the government the responsibility to take these decisions. So the government has to take these decisions. We can't be expecting the government to submit itself to court before it takes a decision with regard to where to arrive at the balance. But as we evolve a jurisprudence, what we're also doing is we're giving government the tools to actually refine its own thinking on how to arrive at the spectrum. And so before we had the right to privacy judgment, we didn't have the proportionality test articulated in the context of privacy. Now we do. In the next case that we have, we may actually say, how do we look at proportionality in the context of facial recognition technology or whatever other technology we're doing. And then the next instance that the government uses it, the government is not walking blind. The government actually now knows the things that it has to do. And so in a sense, I'm trying to balance what Munish said and what Satya said to say that we've got to do this iteratively. Technologies will advance. The government will take a call as to what it does, what it should do. It will get some of it wrong. It will get some of it right. But then when we go to court, the courts will explain. We can't expect the government to ask permission every time. Equally, we can't expect technology. That's, I think, the way we iteratively build the spectrum over a period of time.
Thanks, Rahul. That was interesting. Mr. Manish, do you want to do a quick closing remark for 60 seconds?
Yeah, thank you. I'd like to sum up one or two points, which has been my learning also in this panel discussion. I'm thankful to my co-panelists and to you also. First thing I would again like to mention as a bullet point is that, the government, please understand, let us agree on the process if we don't agree on the result. The process part is the government will have to take a decision, and it takes a decision as per the democratic norms, etc. One. And Satya has always been there in my back of my mind. The second bullet point I would like to mention, which Satya actually said, let us use case wise, because the field is too vast. So on a case-to-case basis, if we can evolve policies which are implementable through technology, then people also have a faith that there's an honest implementation of technology. So I believe there's a really viable solution. Some things like face recognition, what policy and so on and so forth to be more complicated. Something like in a COVID, what should be the policy which the government of India and government of state have already taken? Using Satya's methodology, a software implementing that technology will evoke much more faith and also will be right way to do it, I would say. And we do it, as Rahul said, it has to be done iteratively. I would put it in a different way. Let us keep doing this privacy and public good balance case by case basis and evolve a process where we all agree to the process part of it and find the solutions to individual cases. Thank you.
Thank you, Mr. Munish. Satya, any closing comments?
Yeah, so actually, I like this idea of iterative process that came up in both Rahul's comments and Munish's comments. And this iterative process is, in fact, one of the core ideas that we incorporate into the design of privacy-preserving platforms that we have been designing. And we really think of, very quickly, we really think of our privacy platform as consisting of three layers: a policy layer, a technology layer, and an audit layer. And the policy layer, again, we really borrow from other experts. We are not experts in that area. The technology and audit is where we contribute. And the technology implements the policies, as I said, in a verifiable, transparent way. And the audit, of course, audit layer really generates, for example, on a blockchain, tamper-resistant logs of data flows that anybody can validate, again, in a privacy-preserving way, of course. And also ordinary users whose lives could be impacted by this technology could give feedback based on that, those audit logs. And that feedback goes back to the top layer, the policy layer, and this iterative process can continue. Again, the iterative process that I'm talking about is not, of course, not necessarily the iterative process involving human interactions. I'm really talking about a technological process that is iterative, that integrates all these three layers: policy, technology, and audit. And I want to emphasize that integration of policy and technology is really, really critical. And a lot of problems that we see today all around the world, in my opinion, are due to the disconnect between the policy layer and the technology layer. And luckily for us in India, the influencers of the policy aspects of data privacy or data ecosystem and the technology players influencing how the data ecosystem evolves have a huge overlap. I mean, it could be good and bad, but we really should harness the positive aspects of the fact that the community of influencers of the policy framework as well as the technology framework are really have a large overlap, and they should take advantage of this integrated approach to policy and technology layer. Okay, I'll stop there. Thanks.
Hey, thanks, Rahul, Munish, and Satya. This has been a fascinating discussion. I think, given the expertise that each of you bring to the table, there is a common thread, there is individual expertise. This has been a very fascinating, there's been a lot of learning for me in this discussion. I think getting the right balance between privacy and public good is never going to be an easy solution, right? There will be more questions than answers. I do think technology has a huge role to play. But of course, keeping aside technology, there is going to be a combined effort that is needed from the policymakers, the technologists, the privacy professionals, and now more recently, the ethics. People are talking about ethics of data, etc. And the academia, the government, the corporates. I think this is a huge combined effort to bring this all together to make sure we have the right balance between privacy and public good. Thank you, panelists, for a very fascinating discussion, and thank you so much.